Officer Day, would you open the courtroom for us, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Mr. Riddle. Mr. Riddle.
Good morning, Your Honor. How are you?
Good. How about yourself?
I'm good.
Mr. Haddad. Good morning.
Good morning, Your Honor.
Let's call your case, guys, and get started. This is 22-178-350. Timothy Jakovic versus Wade Prime Properties, Center Management. Your respective appearances, please.
Good morning, Your Honor. Sean Riddell, P81302, appearing on behalf of plaintiff counter defendant.
Good morning, Your Honor. Isadad, P71699 on behalf of the defendants.
All right, gentlemen. Our discovery is closed, and I've gotten a motion for summary disposition. Is there anything else we need to do before I calendar your motions?
Judge, I sent the plaintiffs an offer of judgment for $3,000. They've accepted. We've tendered payment.
Wait a minute, y'all killed more than $3,000 worth of trees.
It's my client's decision, Your Honor, not mine.
Wait a minute. Mother Earth is not happy here.
I know.
So, the offer to stipulate, was going to close out the case. I sent over a stipulated order to dismiss the case, but Mr. Riddell wants a judgment entered. But the payment's been made. So I don't know if that's what the court wants us to do. Now he's got to file a satisfaction. I'll be dismissing the counter claims because we just want to close this file out and dismiss it in full.
Okay.
And so the question is, Judge, does a judgment need to be entered since it's been paid, or can we just dismiss the case?
There's no reason to enter a judgment if the funds have been paid, right?
Your Honor, the reason that we entered, I'm sorry.
You've gotten the funds?
I have gotten the funds, yes.
So what's the need for the judgment? I'm not understanding.
I think the judgment is a clear admission of liability. And being that we've sent the notice and that we've received the payment, all we would do is or file a satisfaction of judgment.
Well, see, the problem is twofold. Number one, we have a counterclaim. That has
right.
Secondly, an offer of judgment is just that, an offer to settle the case. It's not admission of liability. It's just
Your Honor, it is a judgment of liability.
It's an agreement to pay money to settle the case. That's all it is.
With an entry of judgment.
Was that what the offer was?
It is, yes. That's how the offer of judgment rule works.
The offer for simply the amount of money.
It was an offer of judgment. And that's the reason we accepted it, is an offer of judgment has serious sanctions for a party that doesn't accept it. In exchange, what they get is a judgment of liability.
Well, Judge,
That's accurate.
yeah, I don't agree that it's an admission of liability, Your Honor.
Let's do it. Rather than sit here and do spend what's offer of judgment rule?
2.405.
Okay, offer to stipulate 2.405. Because I think what the rule says. The purpose of 2.405 is to, in essence, modify the English rule, the American rule on attorney fees. The American rule, of course, is each side pays its own. The purpose of this rule is to say, if you go past the offer, then you are on the hook perhaps for the other guy's attorney fees. It can't stipulate, the rule does speak in terms, the court shall enter a judgment according to the terms of stipulation. That's what the rule says. So if that's what you guys have done, then I am required under the rule to enter a judgment. I don't know what difference it makes in the case where the parties have settled the case, because the purpose of the rule, like I said, is shifting attorney fees. But if you will not agree to just resolving it without that matter. The court rule says the court shall, that's mandatory language, enter a judgment. I have no
And I
option.
have informed Mr. Haddad that we are willing to stipulate to a dismissal with prejudice of the counterclaims.
All right, then if there has been a acceptance, an offer of judgment, the acceptance of that is within the time period provided by the rule is specific. We have a settled case. The court shall, the language says, enter a judgment in that regard. And then I'll look forward, I'll need the dismissal with prejudice in regard to the counterclaim. So what I'm going to do is I'm going to simply get you guys a term date, thinking that you should, now that you understand the court's position on this, we should be able to close this out.
Thank you, Your Honor, and I'll file a satisfaction of judgment as well,
All right, so let's,
just so that Mr. Haddad has it.
yeah, you should definitely do that. Let's
Mhm.
date. What happened? Here it is. I'm gonna put you on the calendar for closing documents October 7th. I do not expect to have to deal with this case again.
Correct.
And by that time, we should have the judgment in. We should have the stipulation in order dismissing our counterclaim. We should have our satisfaction judgment, and we'll all be done.
Correct. We'll get that satisfaction down to the court today.
So we'll get you October 7th at 10 o'clock. Again, I don't expect to see you guys in.
Perfect. Thank you, Your Honor.
Thank you,
Thank you,
gentlemen.
Judge.
Let's be
Have a good
safe.
day.
Appreciate you coming in.
Mhm.
Bye-bye. Mr. Alderman? Hello?
Yeah, good morning, Your Honor.
What file do you have, Mr. Alderman?
Shirley Staples.
Mission Point versus, okay. I got Fazio here. Let's get him in and get started. Ms. Fazio,
Good morning, Your Honor.
this is 22-188-352. Mission Point of Detroit versus Shirley Staples. Date and time for pretrial. Could I have your appearances?
Sarah Fazio on behalf of the plaintiff, Mission Point of Detroit, Your Honor.
You remember the State Bar of Michigan, Ms. Fazio?
I sure am.
You must have a Buckeye number there.
I do. It's P62046.
Mr. Balderman, your appearance?
I'm Nick Balberman on behalf of the defendant. My P number is 35262, Your Honor.
Okay, what we have here is this looks like our second pretrial. I opened your written discovery when I sent out the notice of the first pretrial. And since that time, a motion for summary disposition has been filed on behalf of plaintiff. Before I calendar that motion, are you guys done with your written discovery?
Well, Your Honor, if I may, there's a little bit of an irregularity I'd like to bring to the court's attention. So Ms. Staples was sued in this matter, and we were contacted by a person who was her power of attorney. According to the medical records, she can't speak. So we were contacted by him, and he's out of state, and he tells us he's her relative. I don't think she has a spouse or children. So we've been working with him, and he sent us a power of attorney, a written power of attorney that was signed by Ms. Staples. And it looked okay to me, but when I looked at it more closely this morning, there's a question as to whether or not it necessarily allows him to act. I mean, it does say that he can act for her financial affairs, but there's a specific box that asks for litigation and 10 other things. And that box, it just came to my attention this morning, isn't checked. So on the one hand, it says he can act for her financial affairs, but on the other hand, the box that says litigation is not checked. So
There is is this a document that was prepared by an attorney or just one of your do-it-yourselfers?
it was prepared, I believe, where he lives, which I think is in Atlanta, Georgia, I believe. And
He's in another state.
He's in another state, and it does look legitimate to me, and he is related to her. And when I spoke to Miss Fazio this morning, she said that he has been involved in her care since the onset, because I guess she can't talk, and she has a laundry list of very serious complications. Miss Fazio told me this morning. I mean, cancer, she can't talk, she had a stroke. I mean, it sounds pretty sad to me. But I'm just a little concerned now that I really drilled down on the power of attorney. Like I said, it does say he can handle her financial affairs, but the box for litigation isn't checked.
So you're not sure whether you have authority to act on her behalf is what it boils down to.
Right. And then to make it a little more complicated, I don't even know if he would be an appropriate, based on some things, whether he'd be the appropriate person to be her next friend anyway, based on certain things. I mean, I'm just not sure. I mean, it's kind of it's not a huge amount of money, but it's a complicated representation issue that I don't know.
What I would suggest, since I do not have declarative power, I would suggest that Mr. Balderman, having filed an appearance, having filed an answer, that you're in the case.
Yeah.
Now, I would seek comfort if I were in your shoes by filing a declaratory action in the circuit court and having the circuit court judge declare, yes, you may handle this litigation, or no, you may not.
Okay.
Because at this point in time, I lack the authority to declare the rights of the parties.
I got you.
The court doesn't have that authority. And my understanding is that, you're, I guess for better phrase, in for a dollar, in for a pound. You
Yeah.
filed an answer, you're the lawyer.
Yeah.
So if you have any questions about the validity of that, my suggestion to be, please commence an action in the circuit court, the Wayne County Circuit Court, and have the court declare, yes, Mr. Balderman, the person with the power of attorney can hire you to handle this litigation, or no, Mr. Balderman, that person cannot. Because at this point, I can't let you out of the litigation.
I understand.
I don't want you to proceed if we have some sort of possible ethical problem.
Mhm.
So what I'm going to do is I'm going to give you another date.
Okay.
I'm not going to calendar Ms. Fazio's motion.
Okay.
And what I expect by the time we get together the next time, Mr. Balderman, is I expect a date for the hearing on your declaratory action in the Wayne County Circuit Court.
Okay.
Not that I'm going to hear it, but I expect you to be able to tell me, the circuit court judge is going to be able to tell us in maybe November, whatever it is.
Yeah.
Yes, I can proceed, or no, I cannot proceed.
Your Honor, as an alternative, maybe what I need to do is go to probate court and get a conservator appointed for her.
That's an appropriate thing to do as well.
Okay.
That's just another problem. But my concern is that my recollection, it's been a while since I did probate.
Mhm.
There are a lot of people that have to be notified, and there are a number of hearings and hurdles that have to be climbed over before you can get to the conservator. And I'm not sure if that's going to be more efficient for you then having the circuit court judge declare, yes, you can represent, or no, you cannot. But that's up to you. Either way, you
All
make
right.
the choice. But
Okay.
prepared the next time we're together to say, this is what the choice I've made. I've either instituted my probate action or I've instituted my circuit court action.
Okay, I'll do that, Your Honor.
All right, let's have you guys back on the 7th of October. Does that work for everybody?
Yeah.
That works.
Okay, October 7th at 10 o'clock, we'll try this again. And Mr. Balderman, I'm not expecting you to have an answer,
No, I understand.
but I'm expecting that we will have the wheels moving in one direction or another.
Yeah, we'll have a path for sure then.
Yeah, okay?
Okay, thank you, Your Honor.
Thanks, everybody. October
you.
7th, 10 o'clock. Let's be
Okay.
safe out here.
Thank you.
Thank
Thanks.
you both for coming in.
Thank you.
We're off the record. Brandon, good morning.
Morning, Your Honor. How are you?
I'm good. How about yourself?
Oh, doing okay. Thanks for asking.
At this time, I don't have your opponent as of yet. So I typically go until 10:30. So I just want to let you know, I know you were here in the waiting room and we'll get back to you. We won't gonna keep you all day.
Okay, thank you, Your Honor. Appreciate it.
All right. Get back to you soon, one way or the other.
Okay, sounds good.
We are on the record. This is file 22180871, American Express versus Francois Jackson. Could I have your appearance, please?
Yes, sure. Good morning, Your Honor. Attorney Jason Brainer on behalf of American Express National Bank. My P number is 69653.
All right. By way of background, this matter was commenced by the filing of a complaint in the 36th District Court on behalf of the plaintiff. Defendant filed an answer. The matter was set for pretrial on June 17th, 2022. When neither party appeared, the court dismissed the matter without prejudice. Thereafter, plaintiff filed a motion to reinstate the case. That motion was heard and granted on August 12th, 2022. The defendant did not appear. Defendant did not file any pleadings in opposition to that motion. Thereafter, again, on August 12th, 2022, this matter was set for pretrial today, September 9th at 10 o'clock. It's now after 10:30. The defendant has failed to appear. No good cause for that failure having been shown. The default of the defendant is hereby entered. Sir, I look forward to your motion for default judgment.
Okay, we'll send that over, Your Honor.
Have a great day. Be safe.
All right, thank you, too.
Yes, sir. We're off the record. Stop video. Turn on the music. Hello?
Yes, hello.
What is your name?
Survivor Davis.
All right. Tavira Davis.
Yeah.
All right, let me see. 9974. Okay, I'll put you back in the waiting room. I don't have the other side as of yet.
Okay.
Mr. Barter,
Good morning, Your Honor. How are you?
good. How about yourself?
I'm doing great, thank you.
What you got?
Jefferson Capital versus Sierra Jenkins.
I think I have Ms. Jenkins. Let's see if we can't get started.
Perfect.
Morning, ma'am. What is your name?
Hi, good morning, Sierra Jenkins.
We are on the record calling 22-189-149 Jefferson Capital System versus Sierra Jenkins. Date and time for what appears to be our first pretrial, your appearances.
Good morning, Judge Robinson. This is on Barnaby 65425 on behalf of Jefferson Capital.
And what is your name again, ma'am?
Sierra Jenkins.
Is it your intention to represent yourself in this matter?
Yes.
You have an absolute constitutional right to do that. What you do not have is a right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that bind Mr. Barter will bind you. Do you understand that?
Yes.
Okay, where are we on this file, people?
Your Honor, this is an initial pretrial. I believe we just need to open discovery and hopefully we can resolve this short of a motion for summary disposition that plaintiff will be filing.
All right, then what I will do is I will open your written discovery. And I'll give you a return date. Your return date will be Friday, October 7th at 11 o'clock. Does that work for everybody?
Works for plaintiff.
How about you, ma'am?
Friday, October 7th at what time?
11 o'clock, ma'am, like today.
Yes, that's fine.
Okay, so what I'm gonna do, I'm gonna send out an order adjourning our pretrial to October 7th at 11 o'clock, opening your written discovery. You think it'd be useful for you guys to talk about the file?
Yes, I believe so. If we go in a breakout room, we don't have to come back in afterwards.
Unless you settle.
That's correct.
Okay, what I'm gonna do is I'm gonna put you in a breakout room. You can talk about your file. If you settle, come back to me. If not, we'll talk again October 7th at 11 o'clock. Your written discovery is now open. Thank you both for coming in.
Thank you.
See if we can get you the breakout room here. 2. Okay. Barter, Ms. Jenkins.
Yes.
We have resolved the matter, Your Honor.
Okay, let's recall your file. Back on the record, recalling file 22189-149, Jefferson Capital System versus Sierra Jenkins. I understand you folks have reached a resolution.
We have,
Yes.
Your Honor, Ms. Jenkins is going to pay $900 in 90 days to settle the matter. So I think we're going to do that in the form of a conditional dismissal. We're going to mail that out to Ms. Jenkins. She will sign it, mail it back. We'll get it to the court, and hopefully we can do that before the hearing date that you've given us on October 7th.
Ms. Jenkins, those are the terms you agree to?
Yes.
Okay, case is settled. I'll send out the order as I've indicated to you earlier. Hopefully, you won't have to be back with me. You'll get your business taken care of before that October 7th date. Thank you both for coming in. Let's have a safe weekend.
Thank you.
Thank you.
What file are you here on?
And what a court can do if the court finds contempt of court. It's a fascinating area of study. There are criminal contempt, civil contempt, and Caleb Donovan.
Sorry, Your Honor.
Not later than Monday.
I actually am at another hearing, which is closed. Okay.
Back to the waiting room.
Communicate to
Should have come on time. We've been done. Other side came on time. They don't have me finished. One more time.
Action. There must be a list.
Morning.
Good morning.
This is Jefferson Capital System. Whoops. Jefferson Capital System versus Charlene Staley, 21-170-332. This is the motion for reconsideration filed on behalf of the plaintiff. Who won the last motion? Your motion.
Thank you, Your Honor. Good morning, Your Honor. Mimi Kalish. My P number is 52383 on behalf of the plaintiff.
As usual, I'm confused. I granted you your request, and now you're asking for reconsideration?
The issue in this case, Your Honor, and frankly, for my client, was what was contemplated was a settlement for the amount of $852 payable at $71 a month over 12 months. And we sent a conditional dismissal to the defendant a couple of times via attached email and regular mail. She never sent it and sent it back. So the issue became when, for right or for wrong, when the plaintiff filed a motion to reinstate, what should have happened, what our attorney should have made clear on that date, is that we contemplated a default provision that indeed, if she didn't make the $71 a month payments, that we could have some recourse and obtain a judgment for the full amount of the balance, plus the court costs and the statutory attorney fee. That is what happened. She made 2 payments, didn't make any more payments. And when my associate appeared before your honor and the court entered its own dismissal, the face of the order appeared to suggest that we would submit a judgment for the settlement amount. In other words, not the amount prayed for in the complaint, less credit for the 2 payments she did make.
Well,
So,
the problem, Ms. Kalish, is that we don't have a transcript. And in whatever was placed on the record is the agreement of the parties. I do not recall the case. Let me tell you that quite frankly. But I don't recall, and that's why I'm confused here. I don't recall any mention of a default provision. That's usually what happens is that the parties say, we've agreed to pay $800, be payable in the following amounts, and then we'll send in the paperwork. So if there was an agreement about a default provision, I want to see it. Otherwise, I'm left with placing on the record the agreement that the parties set forth. So what I suggest might be useful, it might be useful for me to adjourn this for 3 or 4 weeks, give you a chance to get a transcript so we can see exactly what it is that you've agreed to.
I think it's possible, Your Honor, that even with not an independent memory of that particular hearing, which I understand, it may be possible that my colleague during that hearing didn't make it clear that there had to be consequences to prevent the plaintiff in case she didn't pay the compromised amount. What reason would my client have to take basically almost half the amount of what was owed if there were no teeth in the understanding that if she failed to pay, she'd be facing a judgment for the full balance?
That may very well be so. But the only thing I can enforce is either a written agreement signed by the parties, which we don't have here, or the terms that were placed on the record in open court and agreed to by the parties. So my suggestion again would be that you get a transcript from that date, because that will do one of 2 things. It will either say there's default saying some provision saying so-and-so, or there will be no default provision. Either way, we'll know. But I can't just impose a default unilaterally here, which is what you're asking me to do.
I do understand. And I always appreciate the time the court takes to look at the facts and make a ruling based upon what the court is able to do. And I do understand. I think I need to go back to my client and explain Your Honor's position, which I don't disagree with on its face, but I suspect that rather than incur the expense of ordering a transcript, they may have to live with it, because my suspicion is that my colleague wasn't experienced enough in the moment to make clear that we had contemplated and agreed upon a default provision.
Right.
Because the court's right, it wasn't in writing, and I'm not convinced that she said it on the record so that it was clear. I'm sure if he had, the court would have written it that way.
Why don't we have you back October the 14th give you a little time
Okay.
to communicate with your client, decide how they want to handle this.
Okay, I appreciate it. What time will that be?
11 o'clock like today.
Very good. And just to be clear, the defendant didn't call in or appear, or is she here?
She has not appeared, otherwise I'd have her here. Now, let me make a suggestion going forward. Another way of doing this might be to enter a consent judgment for the full amount with the written proviso that if the defendant pays $70 over whatever period of time, that you'll enter satisfaction of judgment.
Yes.
Because that way you have on the record, if you have a failure to do the paperwork, which apparently is going on here, the judgment for the full amount, less whatever credits have been made, and you will have that enforcement provision as part of whatever judgment ultimately gets entered.
I do understand. So the disposition of the case right now, to be clear, is that the case is dismissed and the court was awaiting, it says documents to follow.
That was what our court was told.
So
They didn't follow.
procedurally, as it stands today, the case is dismissed.
No, I think
I'm looking at the February 18th order.
no, you should be looking at the August 2nd order.
Oh,
Plaintiff's unopposed motion to reinstate the case is granted. Both parties appeared via Zoom. Plaintiff shall submit his proposed judgment on the terms set forth on the record on 2/18.
okay.
So the case is live. It was reinstated as of August 2nd.
Okay, so it's just awaiting submission of a judgment.
Yes, on the terms set forth on the record on 2/18/22.
Right, so it would be 8:52, right?
I'll see you October 14th.
Very good. Thank you, Your Honor. I
Thank you.
appreciate it.
Have a good day.
Thank you.
Be safe.
Good morning, Judge.
We are on the record calling 22190-250. Discover Bank versus Sarah Harge. Date and time for what appears to be our first pretrial. Your appearances.
Yeah, good morning, Your Honor. For the record, William Silverman appearing on behalf of plaintiff P41487.
What is your name, ma'am?
Survivor Davis.
Is it your intention, Ms. Davis, to represent yourself?
Yes.
You have an absolute constitutional right to do that. What you do not have is a right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that bind that lawyer will bind you. Do you understand that?
Yes.
Okay. Where are we on this file?
Your Honor, I don't think we've had any discussions with defendant, unless I'm mistaken, on settlement.
Okay. Then here's what I'm going to do. I'm going to open written discovery for both parties. I'm going to give you a return date. Your return date with me will be October 7th at 11 o'clock. Does that date and time work for everybody?
It worked for plaintiff, Your Honor.
How about you, ma'am?
Let me
Friday
look
like
really
today.
quick.
I'm sorry?
Can Can it be on a Tuesday?
You want to do it Tuesday?
Yes, please.
Well, we can change that. We can make it, October 4. Does that work for everybody?
That's fine, Your
That's
Honor.
fine.
All right, October 4. October 4 at 11 o'clock will be our next pretrial. The written discovery is now open. And I'll put you guys in the waiting room. You can see if you can resolve your file. If you can, that's fine. Come back to me. If you cannot, then October 4 at 11 o'clock will be our pretrial, okay?
Thank you, Your Honor.
Okay, thank
All right,
you.
let me put you in the waiting room, in the chat room. Okay. Breakout. Breakout. Assign to room 2. Assign to room 2. Okay.
Judge, we don't have it resolved, but we've discussed it, and I've given defendant a phone number where she can contact our firm if she has any questions about it or if wishes to make an offer.
Okay, well, I'll send out the order then. Thank you.
Thank you, Judge. Have a good day. And I apologize for the delay. I was stuck in front of a really long-winded judge, very much unlike yourself.
It happens. Things like that's occur. Have a great day. Be safe.
You too, Judge.